Good afternoon, folks, and pleasant welcome to Spoon TV. We're live here on the grounds of the Temple of Justice. It's a wet day here in Liberia. It's raining, and the security presence here is heightened as well. As you can see, as our camera will definitely zoom into my far left, you see a contingent of police officers, some of whom are carrying automatic rifles and others were bearing tear gas canister guns as well. Today is a historic day in Liberia as the Supreme Court on its 18th day of sitting, 18th session for its March term of court, will be rendering opinions on 11 cases. 11 cases. The Supreme Court on today will be rendering and handling down opinions on 11 cases. Out of those 11 cases, some of which are property related cases, some have got murder cases as well. Like one of the cases that the Supreme Court has already rendered judgment on is a famous case from Grand Bassa County where a prayer mother was accused of killing a man who had gone to her prayer band. He subsequently went missing and was found dead. The Supreme Court has reversed the murder conviction in that case involving one Martha Doe and has sent down the mandate to the lower court. Case number 8 on the docket for today that is being called as we can speak is that of the Asset Recovery and Retrieval Task Force versus Gracious Ride. That is case number 8. So the motion for this is a rate of prohibition. That is the unconstitutionality of the Executive Order 126 that creates the Asset Recovery and Retrieval Task Force. So that particular ruling will be read by Justice James Etter Wolokoli. So that case is being called, and case number 11 on the docket, the last case for today, is that of the former Chief Justice of the Republic of Liberia, Councillor Gloria Musu Scott, and 3 other co-defendants who were sentenced on the 10th of January 2024. Subsequently, they were found guilty on the 22nd of December 2023 on all 3 counts: murder, criminal conspiracy to commit murder, and making false statements to law enforcement officials. That appeal, the ruling will be handed down as the last for today, and the Supreme Court will then go on recess on tomorrow as to what will be the verdict from the Supreme Court relating to whether the Asset Recovery and Retrieval Task Force that was promulgated by President Baka in Executive Order 126 is constitutional or not. Councillor Wiggins Wright, former Associate Justice of the Supreme Court of Liberia, is the lead counsel for Gracious Ride. The counsel for the Asset Recovery team is headed by Councillor Edward Clamonti, one-time chairperson of the Liberia Anti-Corruption Commission. So whatever the opinion of the Supreme Court, the full bench of the Supreme Court will be, that is going to send a real ripple effect and change the course of what asset recovery and property retrieval is in this country. Remember, in March of this year, President Baka, in his bid to foster accountability and transparency and fight corruption, then declared Executive Order 126, establishing the Asset Recovery and Retrieval Task Force. We then saw the Asset Recovery team, all in the streets, and the most notable case is that of Gracious Ride. Gracious Ride then filed for a writ of prohibition to the Supreme Court of Liberia. That was denied by the Justice in Chamber, Justice Yusuf Kaba. They then took the legal remedy of going to the full bench of the Supreme Court. The full bench of the Supreme Court on the 4th of July entertained arguments in that particular petition for a writ of prohibition. And subsequently, if it is constitutional, Councillor Wiggins Wright argued that the president, if he wants to constitute an asset recovery task force, should have gone to the legislature to promulgate that law or amend the act creating the Liberia Anti-Corruption Commission, the LACC. Councillor Clara Martin argued that yes, the president did have the constitutional mandate to have constituted the Asset Recovery Task Force. He relied on, these are the reliances. I want to give you quote for quote reliances when arguments were made before the full bench of the Supreme Court. So the Asset Recovery Task Force argued that yes, Chapter 11, subsection 11E of the Civil Procedure Law of Liberia was one of the reliances of the Asset Recovery Task Force in their arguments before the full bench of the Supreme Court. They argued that the president establishing Executive Order 126 didn't violate the rights of the petitioner as alleged. He said the executive order is the prerogative of the president. And he also quoted Article 50 of the 1986 Constitution, where he stated that the executive power of the republic shall be vested in the president, who shall be head of state, head of government, and commander-in-chief of the armed forces of Liberia. The president shall be elected by universal adult suffrage of registered voters in Liberia and shall hold office for a term of 6 years, commencing at noon on the third working Monday in January of the year immediately following the elections. No person shall serve as president for more than 2 terms. Councillor Yemin, that's the Associate Justice Yemin Bese Kwekwe, then asked him whether or not it was necessary for the head of the asset recovery team to have acted like a police officer. Councillor Martin was also slapped with another question by the Chief Justice herself, Chief Justice Siane Gio, and she asked whether or not there was enough notice issued by the Asset Recovery and Retrieval Task Force to have alerted those whom properties they were going after. The head of the Asset Recovery then said yes, they made a slight error, but then he also relied on Article 3 and 5C of the 1986 Constitution, where he said the High Court shall rule in their favor because the executive order was rightly and exclusively vested in the president. So we've been hearing a lot of debates in the public corridors as to whether the Asset Recovery and Property Retrieval Task Force is legal. But the Supreme Court on today, as we've been informed by our sources within the Supreme Court as we speak, is listening to the 7th case and is rendering judgment on the 7th case and is going to render opinion on case number 8 that has to do with the constitutionality of the asset recovery or the Asset Recovery and Property Retrieval Task Force that was created by Executive Order 126. So we still want to take you back to arguments that were made before the Supreme Court. Nelson Colette is going to join the rest of the team, and we will definitely be bringing you live coverage. Case number 11, the last case for today, where the Supreme Court, the full bench of the Supreme Court, is going to render its opinion, is the case involving the former Chief Justice of the Republic of Liberia, Councillor Gloria Musu Scott, and 3 other co-defendants who were convicted of the crimes of murder, criminal conspiracy to commit murder, and making false statements to law enforcement officials. All that started in February 2023 when Gloria Musu, a 29-year-old young female, had died in the home of the former Chief Justice. Accusations, counter-accusations, political permutations, political allegations, and the rest mark that particular case. We'll bring you all of the details as to what landed the former Chief Justice and 3 others in jail. They were sentenced on the 10th of January 2024 to lifetime imprisonment on the capital offense of murder, criminal conspiracy to commit murder, and making false statements to law enforcement officials. But back to the Asset Recovery and Property Retrieval Task Force case, the lawyers representing Gracious Ride relied on Article 34I of the Constitution that states that by establishing the executive order violated their rights. They argue that it is the duty of the legislature to promulgate laws, and if the president wanted to create an asset recovery and property retrieval task force, he should have done it in a legitimate way according to their arguments. Go to the legislature that is just next to from his office or amend the LACC Act as to what will be the opinion of the full bench of the Supreme Court. Remember, Gracious Right did file for a writ of prohibition to the justice in chamber. That was denied, and then they took their petition to the full bench of the Supreme Court. So what is going to be handed down today is the final opinion that is coming from the full bench of the Supreme Court. So if the Supreme Court opines that yes, President Braga has got the constitutional mandate to have issued Executive Order 126 establishing the Asset Recovery and Property Retrieval Task Force, meaning the task force is legitimate and they can go to doing their work. Remember, because of the petition filed, the complaint before the full bench of the Supreme Court of Liberia, the Asset Recovery Task Force is not actively engaged as they were. They've been handed down a stay order not to proceed, but we've been informed that investigations are ongoing. So if the Supreme Court hands down an opinion and says, yes, these are just some of the things we encounter, and that's a friendly one. But if the Supreme Court rules in the favor of the appellates, that is Gracious Right, then meaning the Asset Recovery and the Property Retrieval Task Force is illegitimate, illegal, null and void, and that will not just be a blow politically to President Joseph Numa Boakai, but it will also be a legal blow to those who are legal advisors to the president as well. And many have said it will be a dent against the fight, that's the fight against corruption, accountability, and transparency. But for those who are supporters of Gracious Rights and its benefactors and beneficiaries, they've said that, look, if you want to carry out asset recovery and property retrieval, if you have allegations against those who are alleged to have stolen state property, then you should do it the right way. Those arguing on behalf of Gracious Rights have said they are not against the Asset Recovery Task Force, but it should be done constitutionally and legally as well. Kindly let us know the quality of the audio. If it's good, if it's perfect, leave a comment so that our production team can definitely make some tweaks where needed. And if the sound is good, we can continue on this as well. Let's see if we can go to our sources within the Supreme Court. So what we've gathered is that the Supreme Court has jumped over case number 8 and they've gone to case number 9. So whether or not they want to give the rulings on these two big cases in a chronological way, that is what we cannot establish. But we're trying to find out why is it the Supreme Court have jumped over case number 8, which is the Asset Recovery and Property Retrieval Task Force, that they should hand down the opinion of the full bench of the Supreme Court. Those in the chambers of the Supreme Court right now will read out their names as per we received. So on this 18th days session of the Supreme Court March term of sitting, we have Her Honor Siane G.U., Chief Justice, Republic of Liberia. She's in the chambers of the Supreme Court. She's been here since 9 a.m. this morning. Her Honor James Etta H. Wolokoli is also present. His Honor Yusuf D. Kaba is present, and His Honor Yemi Kwekwe Bese Senior is absent due to medical leave. That is what we've been informed. So on the Supreme Court of Liberia, 3 justices are currently in chamber, and those justices in chamber include the Chief Justice of the Republic of Liberia, Chief Justice Siane G. Yo, Associate Justice Her Honor James Etta Wolokoli, and Associate Justice Yusuf Kaba. Justice Yemi Kwekwe Beze is not present due to medical reasons, we've been informed, and Justice, coming to get her name, the newly confirmed Justice of the Supreme Court of Liberia, Justice Clinton Johnson, has not taken her seat yet. So meaning there should be 4 justices of the Supreme Court of Liberia in chamber. Justice Clinton Johnson has not been seated yet in the Supreme Court of Liberia. So now we have 3 justices in chambers as we speak. Justice Yemi Kwekwe Bese is on a medical absence, we've been informed. So we'll be giving you live updates from the Supreme Court of Liberia. 11 cases today for opinions to be rendered down. from the full bench of the Supreme Court, and they've jumped over case number 8, which is that of the Asset Recovery and Property Retrieval Task Force versus Gracious Rights Incorporated. Nelson Colette is definitely going to join on, and we'll have a conversation about this, not just the legal ripple effects of what the opinion will be, but also the social effects as well as the political effects that might arise from this case. So we'll keep you posted. And remember, case number 11 is that of the former Chief Justice of the Republic of Liberia, Councilor Gloria Musu, and 3 other co-defendants who are the appellates versus the Republic of Liberia through the Ministry of Justice. They are the appellees. So remember, we'll bring you all of what is unfolding here. Keep your comments coming in, and we'll be back and forth with our sources within the Supreme Court of Liberia. So now they're rendering judgment on case number 10. So the justices have jumped over case number 8, and from all indications, because these are the two of the cases that are very, 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 very pivotal to the public opinion, not just Liberians home, but Liberians abroad as well. Our international partners and the rest are definitely following what is happening in our country with these landmark rulings. So they're now on case number 10. We've been informed that the justices are rendering their opinion on case number 10. Nelson Colette is going to join me, and together we'll continue this broadcast. Pleasant afternoon to you, Nelson.
Yeah, good afternoon, Diamond, and let me say good afternoon to our folks across the world joining us. This is a historic day for our country, and like you put it right, Liberians are concerned, not just those in Liberia, but across the world. They are concerned, eagerly awaiting what the outcome of the ruling will be today. So I see there's a huge presence of security here today as
Of
well.
course.
Even driving here it was a more different atmosphere as compared to what it would be on a regular day here at the ground of the Temple of Justice. Yeah, so this is a historic day, and it's just important that Liberians remain glued to get all of the updates every step along the way as we provide the information here today.
Okay, so information as we've been providing to you, now there are only 11 cases, as I said, on the docket for today, Nelson. And case number 8 is that of the Asset Recovery and Property Retrieval Task Force versus Gracious Right. Remember, it's Gracious Right that sought an appeal from the full bench of the Supreme Court of Liberia after their petition for a writ of prohibition was denied by the justice in chambers. That is a legal remedy. They sought to appeal to the full bench of the Supreme Court of Liberia. That is case number 8. And their argument is that the Asset Recovery and Property Retrieval Task Force that was created by Executive Order 126 as issued by President Joseph Imambuaka in March of this year is unconstitutional. Their argument is if the president wants an asset recovery task force, he should have used the legislature to promulgate the laws and establish that task force, or he should have amended the LACC Act. Now, the Supreme Court, through its own ingenuity, has decided to deal with the other cases and leave number 8 and 11 as the last two. Why do you think that is the way the Supreme Court wants to go instead of doing it in a numerical order as has been done for the first 7 cases?
Well, one thing that I know is that the Supreme Court is doing this based on the order of importance. All right, you talk about the asset recovery, the case of the asset recovery team. This is one of the big cases we've had in the country, like the case with Gloria Musu's car. This is one of the cases that kind of implicate the executive branch of government of Dominican law. And if you go back a little to the executive order, and I remember reading through that executive order when the president stated that one of the reasons why they had to set up that asset recovery team, using the executive order was because of the urgency attached. They didn't want the regular legislative filibustering and all of that, so they had to do it. The president told them why to bring through the executive order so that they would be effective, they would immediately start to function. So, given the importance of the team
Mm.
how to go about this. And they're using their judicial expertise, their legal expertise and all of that to handle this thing. But at the end of the day, what I think, Diamond, is that Liberians should rest assured that there's going to be a ruling handed down in this particular case. It's going to settle the matter, and I think that's what matters the most. And yes, but again, the Supreme Court has a reason maybe why they're skipping this particular case. And then another thing is, once the ruling for Councilor Gloria Musu's car and the child Musu thing and all of that comes out, it's a whole different atmosphere. You saw what happened here, the previous report
Yeah, yeah. When they were convicted.
when they were convicted. And so it turns out to be it creates an atmosphere where a lot
So
of people,
it's a smart move to decongest the grounds of the capital of the Temple of Justice, because if you look at what is unfolding now, there are many cases ongoing. As I said, 11 cases on the docket for opinions to be rendered on from the full bench of the Supreme Court of Liberia, Nelson. We have a very heightened presence of security officials as well.
yeah,
What we haven't seen so far is the gathering of political supporters or sympathizers. There are family members and supporters around, but they're not gathering in large numbers. They're in smaller pockets, and the crowds are being dispersed. And remember, the Supreme Court also goes on break, on recess on tomorrow.
yeah.
So these landmark cases being left for last for ruling to be handed down upon. That is a strategy they're employing based on how sensitive these two cases are. Let's go back to the asset recovery, because that is
Yeah.
the first on the list before we move to the appeal from the former Chief Justice and the three other co-defendants, who gave the whole story as to how we got here today to have a former Chief Justice appealing a murder conviction as well. But back to the asset recovery, Nelson.
Yeah.
We did see the different public opinions, and we've seen from different political sides, whether from those supporting the gracious right and its owner, the former chief of protocol, Nora Bondo, or President Weah, as his name has been linked to it, or those who are supporters of President Boyka, and ordinary Liberians in the middle who have said, look, we want transparency, we want accountability, we want properties and assets to be retrieved, but how is it done? And it cannot be done minus political filibustering and political posturing, Nelson, as we've seen. So either side are trying to use the public as to sway opinions, but this is before legal luminaries, those who will be relying on the laws. Before the full bench of the Supreme Court of Liberia, you're talking about well-versed lawyers who served as judges either or they were lawyers and subsequently brought to the bench of the Supreme Court of Liberia. Either way, it's based on whatever preference the president at the time decided to employ. But now you before experienced lawyers, you speaking to witnesses, you're not witnesses, you bring in evidence from the lower court. You're speaking to career lawyers who are looking at what the law has as reliance.
Yeah.
But remember, this full bench of the Supreme Court of Liberia has also slapped the executive before, just a few months back.
Yeah.
And that was about tenured positions.
With the LTA and all of that.
Yes, that was about tenured positions. Though they slapped the executive by saying the appointments of individuals into positions that were already being occupied by tenured officials was unconstitutional. The executive found its way immediately after accepting the result. The next day, the president suspended, which was not questioned. And those who ran to the court, that was said that the president has got the constitutional right to have suspended them as per investigations ongoing. So yes, the Supreme Court has slapped the president before, relying on the law. What will be the outcome? That is the question. Is it going to be in favor of the Gracious Right Incorporated, or the president's executive order 126 is going to be upheld as constitutional, Nelson?
And that is where it gets very interesting now, because we have seen that this Supreme Court under this administration, and whichever way has ended up against that did not go the way of the government, like in the case of the LTA you just mentioned, and the other
The
cases,
NRR and the rest of those.
and the rest of those, and that alone, to some extent, made the Supreme Court to gain the trust of some of those who are not supporters of this administration, some of those who may want to think that the Supreme Court will be in the business of rendering justice, coming down with ruling in the interest of this government because they want to be working in line with the executive and all of that. So the Supreme Court, to some extent, has created the atmosphere for people to at least trust this particular court. So, given where we are now at this point in time, I think it's going to be very interesting, and the ruling here today is something that is highly unpredictable. It's kind of difficult to predict because if we have had a situation where the court has consistently ruled in favor of the government, someone may want to predict that, oh, okay, this one, like that as always, is going to be in the favor of the government. If we have had cases where they have always been against the government, someone may have reason to say that, oh, okay, as always, it's going to be against the government. But given what we see the Supreme Court done over the time, it makes this particular case highly unpredictable. We can make the analysis around it. Liberians, even out of Liberia, can have their expectations, but at the moment, it's kind of unpredictable.
One thing that is predictable, Nelson, one thing that is predictable is the fact that whatever opinion that comes from the full bench, remember, it's coming from the full bench of the Supreme Court of Liberia, there might be justices with dissenting views. Depending on how many of these justices have got dissenting views on the matter, or otherwise it was a unanimous opinion from the Supreme Court of Liberia in favor or against either of the two parties, it is going to go down as a precedent ruling. So other cases that may arise in the future will be referenced. They will use this ruling as a reference as well, because now we're talking about the constitutionality of the president's executive order 126. And if the And if the Supreme Court, the full bench rules that yes, the president's executive order was constitutional, it has the reliance as per the Constitution, or it rules that it was unconstitutional, the effects are going to be far reaching from just the Supreme Court of Liberia. It is going to affect the ability of the Asset Recovery and Property Retrieval Task Force, because now it is null and void. Meaning the president has to go back with his advisors, whether legal, political, and the rest, to see how they can reconstitute. Mind you, it is going to go with prejudice as well, because those who have been targeted, they've said they've lost, monies by their vehicles being impounded for the number of days they were impounded. Their company has been referenced as illegal, illegitimate, or have been involved in some acts of criminality, and the rest. They suffered damages, whether or not after the ruling, depending on either way the ruling goes. If it goes in favor of Gracious Right, whether or not they will sue the government in a civil suit, if it goes against them, then you will see the Asset Recovery Task Force with teeth to bite.
Yeah, and that's exactly where it stands. I don't know exactly what but that's exactly where we stand. And you know that the work of the Asset Recovery team.
1 minute, Nelson. Let me interrupt you. Case 11 is on. The ruling now into case 11, which is that of the former Chief Justice Councilor Gloria Musu and 3 others who were convicted on the 22nd of December, right here at Criminal Code A, on the grounds of the Temple of Justice. They filed an appeal to the full bench of the Supreme Court of Liberia to overturn the ruling of the lower court. Now, what is going to happen if the Supreme Court rules in favor of the appellates, that is Councilor Musu and the 3 other co-defendants? A mandate will be sent down from the Supreme Court of Liberia to the lower court that sentenced them to reverse, that verdict and the sentence. And the prosecution will have to be present for that mandate to be read to the lower court before they can subsequently be released. As to whether that will be done today, that is, we're not preempting what the judgment will be, but we're saying if it goes in favor of the former Chief Justice and the 3 other co-defendants, that is the process. But if it does not go in favor of the former Chief Justice and the 3 other co-defendants, meaning their sentences have been upheld and the ruling is upheld, the Chief Justice herself is the one delivering the opinion of the full bench of the Supreme Court in this matter involving the former Chief Justice Councilor Gloria Musu Gertrude Newton, Old Lady Euda Wisner, and Alice Johnson, rising out of the murder case of the late Gloria Musu, 29-year-old ward, on the 22nd of February, where she was murdered in the Broadway residence of the former Chief Justice Nelson. We followed the case. The former Chief Justice was detained at the headquarters of the Liberia National Police, and subsequently they came to the Monrovia City Court, where her lawyers filed for a writ of habeas corpus. She was released on the 23rd of June 2023, and on the 24th, she was rearrested, brought to the Monrovia City Court. Her lawyers filed for bail bond. They were denied. Since then, she's been behind bars, but a pre-trial detention or after her conviction since the 24th of June 2023. If we look at the number of days between pre-trial and sentencing, she has spent a total number of, I'm trying to get the days, she has spent a total number of, okay, now see, I'm trying to get a number. I did that calculation. So between pre-trial, she spent 163 days on remand. Yeah. Between pre-trial and subsequent sentencing, she was sentenced on the 10th of January 2024. That was 163 days, making it 6 months and 16 days. After her sentence, she has served a total of 231 days. That is 6 months and 50 days, or 7 months and 19 days. So if you add the 6 months and the 7 months, you can do your math. That gives you 1 year and 3 months since she's been behind bars there at the Monrovia Central Prison.
You know, and this is where it gets even more interesting because
Another information quickly, Nelson, sorry for interrupting you. So the Solicitor General of the Republic of Liberia is not present. He has been fined 100 USD, while the Ministry of Justice has been fined 200 United States dollars for being absent as the Supreme Court is handling down the opinion in this case involving the former Chief Justice. So that is breaking news coming from the temple of the Supreme Court of Liberia. The Solicitor General has been fined 100 USD for being absent for this ruling. And the Ministry of Justice in itself has been fined 200 United States dollars for being absent. Nelson, you were on the train of thought.
you know, that's something that will definitely be anticipated because in such a ruling, this is a landmark case. You know, anyone would expect that the Solicitor General will be present here today and stuff like that. You know, but I was just going back to the the initial point you made relative to how long the former Chief Justice stayed behind bars and all of that. Now, Diamond, you know that consistently, and I remember when they when she was when the guilty verdict was handed down, she had consistently said she's guilty, she's innocent. She has consistently every single step along the way, even in the courtroom when the guilty verdict was handed down, she took up about 15 meetings to curse those people who according to her have fabricated this entire thing against her, trying to defame or her high-end reputation and stuff like that. So, given what we see over the time, and considering that she spent that amount of her time behind bars for what she said she did not do, even with the ruling today, Diamond, this is where it stands. Even with the ruling that's going to come up today, if the former Chief Justice is set free today,
that is a big if.
And that is just if she's set free today, I believe that she's still going to have some issues. And that's where maybe we're going to see the next step, the next course of action. She being a legal practitioner, what she's going to do with respect to everything she has gone through individually, in terms of her mental health and socially, everything that
we also should be quick to point out the fact that we have a divided nation. When it comes to this case. There are divisions in the public glare. Those who feel like in a country of ours, Liberia, justice cease, especially based on your social status or whatever position you've occupied in Liberia, or whether you wield some a level of wealth in the country. And there are those who are also divided on a political basis. That look, she was politically persecuted by the CDC, and now a party for which she supported. She was one of the lead counsels when they had electoral issues, and they went to court. She's now being set free by her party. If the Supreme Court reverses or overturns the ruling of the lower court, if the Supreme Court says that, look, during the arguments by both the defense and the respondents, that there wasn't sufficient evidence, there was reasonable doubt. Remember, it's a criminal case. Whether or not reasonable doubt was established, whether or not the state presented, substantial evidence, irrefutable evidence, whether the state relied on circumstantial evidence that had loopholes and all of that, or whether or not there were procedural errors. One thing that Liberians should not forget is that a young lady in the prime of her life, 29 years old, lost her life. As to who the murderer is, legally, if they are acquitted today, if the ruling is reversed, there will be a murderer out there. If the ruling is upheld by the Supreme Court of Liberia, many murderers are put in jail. And so there are different divides, different sides to this. But one thing that Liberians should also take from this case is the fact that we need to look at our criminal investigative branch of our country. How do we maintain crime scenes? How are crime scenes preserved? How do we carry out investigations? We're relying on eyewitnesses' accounts. We don't have so much of forensic investigation, DNA, and the rest. Should we start looking at this? Because for average Joes who do not have the monetary, capability to seek an appeal, to have lawyers and all of that, where do they stand in a country where investigations is usually marred by, trampled upon or violated crime scenes? So either or, Nelson. The Chief Justice, as we getting reports, is reading the history. She's reading the history of she's reading the history of the case from the lower court. As I said, the Chief Justice enjoyed a day. The former Chief Justice enjoyed a day of freedom on the 23rd of June 2023. That is when the writ of habeas corpus was granted by the Monrovia City Court. She was subsequently rearrested, indicted by the grand jury of Montserrado County. They filed for bail bond, that her personal reconnaissance said that she's a state person, she's not a flight risk. That was denied. The city court said it lacks the jurisdiction over murder, and the defendants should have used the pre-trial remedy that was accessible to them. They did not. I remember that case vividly. It was then transferred to Criminal Code A. Again, they attempted to get her a bond from Criminal Code A. That wasn't successful. She was placed on remand, she and the 3 other co-defendants. And since then, she's been at the Monrovia Central Prison, which is known as South Beach, until she was convicted. She and 3 others were convicted. They came out of this particular door that is just right behind us, using this very entrance. And they were convicted and subsequently sentenced on the 10th of January this year. So Nelson, whatever the case is, whatever the ruling will be, this is also a precedent ruling as well.
A precedent ruling, it is, because for the first time we are seeing a high-profile, a high-profile personality, someone who is thought to be one of our best legal minds in the country, going through such a intense legal process.
A one-time senator as well. One-time Minister of Justice.
And stuff like that, going through this entire process. It's like being tried in the very office where you tried other people before. And what this case sets out to folks out there, what we should all capture for this case is that the table turns at any time. You could be here today and on the other side tomorrow. So we should all just do what we can in the confines of the law. But Diamond, as you know, there's a political twist to this whole thing.
As well.
That's why this being a legal process, and we want to go into the legality and the legal aspect of this entire thing. But the political side of it is something to look at.
Yeah, we'll definitely get to the political side, Nelson. It is evident this case has been more political than legal in the public glare, in the public space. There's been a lot of political connotation to this particular case. But update from the Supreme Court, the Chief Justice has skipped reading the entire indictment. She says it's 100 pages. So she has urged the media to read it and publish it for Liberians. So she has skipped the process and she's on to really what the ruling will be. As you were rightly stating, Nelson, there is a political connotation to this particular case as well. It has been said that the former Chief Justice and the three others were illegally detained, subsequently found guilty by a jury that was allegedly tempered with, a lot of allegations from both sides of the aisle. Mind you, those who are supporters of the CDC, if you want to go political, are going to say, look, we convicted legally using the courts, and the Unity Party government has come to release again using the courts somebody who committed murder. No matter how you do it, there will be a political connotation to this.
It's going to be a difficult one because we know that if you want going back to this whole case, there were issues with of jury tampering,
allegations that were not substantiated,
and all
during
of that.
the arguments.
And then there were also times where we saw that
The former Solicitor General paid a visit at an odd hour and all of that.
Yeah.
He said he only came to tell the jurors that were circumscribed, that look,
So aside from the jury tampering, another thing that happened is that some of the high profile, some of those people who were very influential under the previous administration were being linked to this case. Some of them had to come and explain, give their own side of it, and of course the legal process went on. And like you rightly said, the former Chief Justice was being convicted. Now, if she gets released today, what the folks from that end are going to say is that, oh yeah, we said it. This is a whole partisan thing. We were there, we did the right thing, and the administration now is setting her free because of X, Y, and Z reason. Now, but if, on the other hand, and just if the
ruling is upheld,
the ruling is upheld today, what is going to be interpreted? What is going to be the interpretation out there for the political folks and all of that would be? We told the Liberian people that this was the people, that X, Y, Z is what maybe the former associate, the former Chief Justice did, and all of those people we convicted, indeed did it. They doubted our process and all of that, but in fact, under their own administration, their own Supreme Court, or the Supreme Court under their administration, is upholding the ruling that we came down with. So it's a whole difficult thing here with respect to what the interpretation of the ruling from the Supreme Court today is going to be out there in the public, and the interpretation is going to come out based on where one sits.
Hold on. So what we're getting is that the trial judge's ruling was 36 pages, and the Musu team filed a 100-count bill of exception. Now what we're getting is that, let me get this information right, whether or not there was no direct evidence to link the defendants. Mind you, what happened was it was a class action. They didn't stand trial as individuals. It was a class action. And whether the state was able to prove beyond all reasonable doubt that the four defendants conspired criminally to have killed Chalo Musu using a sharp object. Then whether the state was able to have established motive, what was the motive to have killed the late Chalo Musu? Whether they conspired before killing her or conspired after killing her, that is conspiracy after the fact, whatever the case is. The appellates argued that there wasn't enough evidence to have prosecuted this case, to have convicted them beyond all reasonable doubt. Beyond all reasonable doubt states that even a layman, when you explain this to him, he shouldn't have any speck of doubt that whether or not, this person committed this act or not. Whether the forensics was spot on, whether the expert witnesses were spot on, whether or not this was an ironclad prosecution, open and shut case by the state, whether doubt still exists, whether these four individuals committed the crimes for which they were convicted of and subsequently sentenced to life imprisonment. Again, the ruling is being read by the Chief Justice of the Republic of Liberia, whether one Chief Justice is going to read an opinion that will set free a former Chief Justice. That is the question. Or whether one Chief Justice is going to read an opinion that is going to seal the fate of a former Chief Justice. That is the question as well. But we hear after this opinion is being read, the Asset Recovery and Property Retrieval Task Force ruling by the full bench of the Supreme Court will also be handed down. So two landmark cases, two landmark rulings currently happening. Nothing before I get to you can see that the officers are staging and stationing themselves around. You can see riot police officers. Some of them are carrying tear gas, canister guns. Others are carrying automatic rifles. We've asked our legal, sources whether or not if the former Chief Justice and the three other co-defendants are acquitted today, if the ruling is reserved, if the ruling is reversed, I should say, whether the rule of double jeopardy applies in this case, where you cannot prosecute a person two times for a case that they've previously been prosecuted of and subsequently won their appeal, whether or not you can go back and prosecute, whether double jeopardy applies. And they did say that yes, in this case, if the ruling is reversed, if the Supreme Court comes down and say, look, it overturns the ruling of the lower court, double jeopardy applies in this case. And usually when a ruling from the full bench is handed down in favor of an appellate, it's difficult for the state to re-prosecute. It's difficult for the state to go back and follow up on the case because the state would have exhausted all of the remedies available in making sure they could have prosecuted that person beyond all reasonable doubt. And if that is the case, a lot needs to be desired from our investigation and prosecution in our country, Nelson.
Definitely. I think I need to get back to you so we put it into the audio and all of that.
Okay. Okay, we don't have good audio?
Yeah, we have a little bit of
Okay, so our producer is going to make sure he works on the audio quality. Just leave a comment to let us know. We're live here on the grounds of the Temple of Justice. My name is Diamond Slanger. I'm here with Nelson Colette presenting to you what's unfolding currently. The Chief Justice of the Republic of Liberia, Chief Justice Siane Yo, is reading the final opinion from the full bench of the Supreme Court in the case involving the former Chief Justice of the Republic of Liberia and three other co-defendants, namely Gertrude Newton, Alice Johnson, and the rest of them who were convicted of the crime of murder, criminal conspiracy to commit murder, and making false statements to law enforcement agencies or officials. The state brought 13 witnesses according to what the Chief Justice is reading. Please let us know the quality of the audio. If the audio quality is good, we want to make some quick adjustments to be right back. You will lose audio for a bit, but let's make some quick adjustments to be right back.
Okay, so Diamond, I think
Testing the audio quality. Please let us know if the quality
that's being used. Let's hope this audio can serve us well.
All right, so please leave a comment of the audio so that we continue this live coverage. Diamond Slanger and Nelson Colette right here on the grounds of the Temple of Justice, where two landmark rulings will be handed down by the Honorable Supreme Court of the Republic of Liberia. So your comment is need
had to testify of the happening. And so I remember it took over an hour. Some people were even impatient. The going to take a little how it goes, but at this so this is the defining moment. This is what will determine as to whether the ruling from the lower court will be upheld, or there will be a guilty verdict in this case. But then another thing, Diamond, is that what I noticed here is that the atmosphere is a bit different from what we saw in the previous situation, right? So in the previous ruling, you will see pockets of maybe political party supporters, folks from different groupings, organizations, whether in favor of or against the former Chief Justice. They will all be here on the grounds of the form justice, but it's a whole different case. And some level of work being done here by there is what appears to be some level of work being done here by the state security issue. The grounds of the form justice is protected, stand in the face of
You said even the main gate leading to the temple opposite the executive mansion is locked. You must be someone who has got a case here, or your name is on the list as a media practitioner or media institution to make your way here. So security presence here is heightened. To what the ruling might be, Jurassic will just spin the camera as you can.
Alright, so we making adjustments to
audio quality. Again, please let us know the quality. Leave a comment. Let us know. We faced with some technical glitches here, but your comment is very pivotal to making sure that this broadcast is perfect when it comes to audio quality as well. So please comment, leave your comment, and let us know what the audio quality is for now. We'll be bringing you live happenings from within the Supreme Court of Liberia. The Chief Justice, Her Honor Siane Yo, is reading the testimonies from witnesses from the lower court in the case involving the former Chief Justice of the Republic of Liberia and 3 others who were convicted on the counts of murder, criminal conspiracy to commit murder, and making false statements to law enforcement officials arising from the case of the late Gloria Musu that was found dead on the 22nd of February in the Breville home of the former Chief Justice of the Republic of Liberia, one-time Senator of Maryland County and one-time Justice Minister of the Republic of Liberia. The former Chief Justice did say that there was an assassin that entered her house. During her accounts of what unfolded, she said she had a near-to-death encounter with the supposed assassin and subsequently pepper sprayed assassin as well. Persons of interest were also brought in by the Liberia National Police. One of those prominent persons of interest at the time was the mayor of the city of Monrovia and Secretary General of the opposition Congress for Democratic Change, Jefferson Tambakoji, and of course the infamous name Valley Tele. They were subsequently cleared by the LNP as being people who did not possess any further information. They were not important to the investigation, and subsequently were not promoted from persons of interest to suspects. Later on, 4 months down the line, the former Chief Justice was then invited by the Liberia National Police with 3 others, including those 3 others that have been convicted alongside her, to the offices of the Liberia National Police, where they were subsequently detained and charges were leveled against them. They were whisked away, where they spent the night at the headquarters of the Liberia National Police. Their lawyers then filed for a writ of habeas corpus that was granted by the Monrovia City Court. All that was on the 23rd of June 2023. She went home, and the next day at her 17th Street residence was served a writ of arrest. She and the 3 other co-defendants were served writs of arrest, subsequently brought here to the grounds of the Temple of Justice, read their charges, and whisked away to the Monrovia Central Prison. There they've remained up to this day. On the 22nd of December, after 5 months of gruesome testimonies, eyewitnesses accounts, expert witnesses presented arguments from both the accused and the defendants and the state. They were subsequently convicted of the crime of murder, criminal conspiracy to commit murder, and making false statements to law enforcement officials. On the 10th of January 2024, the former Chief Justice, Councillor Gloria Musu, Gertrude Newton, Old Lady Ude Wisner, and Alice Johnson were sentenced to life imprisonment here by the judge of Criminal Court A. According to the Supreme Court, what is happening now, they've appealed their verdict from the lower court that the state didn't present irrefutable or substantial evidence that there is sufficient doubt to have clouded the process. They argued that jurors were tampered with and there was already malice against them for political reasons, and hence there were procedural errors and the rest. The Supreme Court listened to arguments from both the appellate's lawyers and the appellees, and subsequently reserved ruling for today. What's going on in the Supreme Court as we speak? The Chief Justice is reading the eyewitnesses' accounts, and we can confirm to you that the former Chief Justice, Councillor Gloria Musu, and the 3 other co-defendants are not in the chambers of the Supreme Court of Liberia. Only their lawyers are present, and you cannot present new evidence to the Supreme Court. When you go to argue before the Supreme Court in an appeals process, you take whatever evidence and whatever arguments that were presented to the lower court to the Supreme Court for your arguments. New witnesses cannot be introduced, new pieces of evidence cannot be introduced. It is just the ruling and all other arguments and pieces of evidence that were presented during the lower court trial that can be presented to the Supreme Court of the Republic of Liberia. In other countries, there are multiple layers of an appeals process, but in Liberia, from the lower court, you go straight to the Supreme Court, whether before the justice in chamber. If you do not get the redress for which you sought, then you take it to the full bench of the Supreme Court of Liberia. Justice Yo has just reiterated that the late Gloria Musu was stabbed 9 times according to witnesses' testimonies. 9 times according to witnesses' testimonies. So again, only the lawyers representing the former Chief Justice and co-defendants are within the chambers of the Supreme Court of Liberia. The government of Liberia should have been represented by the Solicitor General of the Republic of Liberia and the Ministry of Justice. They are a no-show. So the Solicitor General has been fined $100 United States by the Supreme Court of Liberia. The Ministry of Justice in itself has been fined $200 United States by the Supreme Court of Liberia for being absent during this ruling. Again, whether that is a sign that the Republic, has hinted, or they do know that they are going to lose this ruling, well, that is something you can deduce for yourself. But the Solicitor General of the Republic of Liberia is not present. The Ministry of Justice in itself is not present for this ruling to be read. So now the Chief Justice is done reading state witnesses' testimonies. She's now reading the testimonies of defense witnesses. She's then reading the testimonies of defense witnesses. After this, they will now go to the opinion, relying on legal precedents, relying on legal reliances to hand down the opinion of the full bench of the Supreme Court of Liberia. Whether or not the former Chief Justice and 3 other co-defendants, their conviction is going to be overturned, the ruling from Criminal Court A is going to be overturned by the full bench of the Supreme Court, we cannot tell you. What we can tell you at this moment is what's unfolding there in the chambers of the Supreme Court of Liberia. The Chief Justice herself, Chief Justice Siane Yo, is the one reading the opinion of the full bench of the Supreme Court. This tells you the important nature of this particular ruling, not just to Gloria Musu, who once served at the highest office here in the judicial branch of government, but also to the entire Republic of Liberia and Liberians home and abroad. Whichever side of this divide or side of this coin you find yourself, a young Liberian, 29 years old, lost her life on the 22nd of February 2023. As to whether it was done by an assailant that is at large or it was done by the 4 defendants that have been convicted, we will know if legally they will be cleared or their convictions will be upheld. In the instance where their conviction is upheld from the opinion of the full bench of the Supreme Court of Liberia, they cannot exhaust any other appeal process. This is the end of the road. It's signed, sealed, and delivered. But in the instance where the Supreme Court opines that there was reasonable doubt, the trial process was marred by irregularities, and hence overturns the verdict of the lower court and subsequent sentencing of the lower court, meaning a mandate will be sent down from the Supreme Court of Liberia to Criminal Court A, instructing that their ruling has been overturned and the rights of those convicted be restored. Whether or not they will be released today, that is, if the Supreme Court rules in their favor and the mandate is sent down, that cannot be answered for now. If the Supreme Court rules in their favor, meaning the rule of double jeopardy will also apply, meaning we might not just see Gloria Musu and the 3 other co-defendants returning to court, where there is usually prosecutorial reluctance, I should say. Nelson, you can kindly join me for us to have this conversation as we bring you live. Remember, case number 8 that was jumped over by the Supreme Court is that of the Asset Recovery and Property Retrieval Taskforce versus Gracious Right. And that case is not about reasonable doubt. That case is about constitutionality. That is the problem. So the Gloria Musu case is about overturning criminal conviction, stating that there wasn't reasonable doubt enough to have convicted them, whether there was procedural error, whether the investigation was flawed, whether the jurors were tampered with, based on evidence before the Supreme Court, the full bench is going to rule. But in this case involving Gracious Right, Nelson, it's about constitutionality, whether or not the president has got the constitutional power as enshrined in the 1986 Constitution to have established an asset recovery and property retrieval task force, or he stepped way out of bounds and or usurped the powers of the legislative branch of government.
You know, and this is a landmark case as well, because like we've always said, Diamond, these cases will set will set precedent. These cases will be revisited in time to come when we have similar cases, resurfacing and stuff like that.
Just a quick update. So the Chief Justice is reading that the investigation established that the state failed to provide the instrument that was used to stab Chalo Musu 9 times, meaning the state failed, investigators failed to have provided the supposed murder weapon. Remember, if the murder weapon was provided, you could have done a fingerprint analysis. You could have done DNA testing to see who else handled that knife or whatever object that was used. But it's reported that it might have been a knife or any other sharp object by the piercings and the marks that were made. So the Chief Justice is reading that the investigation showed that the state failed to have provided the object or instrument used to have stabbed the late Gloria Musu 9 times, Nelson.
You know, and that's a great update, because Diamond, I remember when there was this argument, you know, before the previous ruling, the defense counsel, the defense lawyers argued that it wasn't possible for all 4 persons to hold a single object and stab Gloria Musu maybe 9 times or so. You know, so again, it was on the prosecution to come up with the pieces of evidence to prove beyond all reasonable doubts as to what the possibilities are for such to happen. You know, and so it comes as no surprise, and I think this is just the route the Supreme Court is going. But again, we look forward to what the entire thing will be, because that's just a segment of, you know, the ruling from the Supreme Court. They're looking at the pieces of evidence. They're looking at the basis on which the lower court handed down the previous ruling, and then to be able to derive at, you know, whether a verdict, you know, to uphold the ruling, you know, and or accept the appeal from the defense counsel. So this is where we are. But Diamond, going back to the asset recovery case.
That's what we'll be doing. We'll go to the Gloria Musu appeal, and we'll go to the asset recovery gracious rights appeal, because mind you, that ruling is not yet handed down by the Supreme Court of Liberia. That opinion is still hasn't been read yet.
Yeah.
They jumped over case number 8 and went straight to case number 11. That is the Gloria Musu case. But whatever may happen, be it whatever it is, those 2 rulings from the full bench. Remember, it is not justice in chamber. It is the full bench of the Supreme Court of Liberia. Now on the full bench, we only have 4 justices, though we have a 5th justice, but she has not been seated. We've been informed that sitting might be done on tomorrow as the Supreme Court closes its March term of
Judge
sitting.
Clinton,
Judge Siane Johnson Clinton. Clinton Johnson. She's going to be seated. So now, out of the 4 justices, only 3 are present at the moment, but the opinion is going to carry the ruling is going to carry the opinion of all 4, because she's not yet on the bench, so she cannot give an opinion on a matter until she's seated. So the opinion is going to carry the ruling is going to carry the opinion of all 4 judges.
It's like the legislature. You have to turn, right? So we have 5 persons on the bench. You know, if we have 3, we have to turn. We have majority, which
Judge Bese is not in the chamber today. His name is on the docket, on the document, but he's not present because of medical reasons. We've been informed. So Justice Yemi Kwekwe Bese is not within the chambers of the Supreme Court as we speak, but his opinion, we've been informed, is also present in the ruling. So we've gotten another update that there were contradictions between the 2 pathologists' report, raised murmuring in the courtroom. So the Supreme Court is also reading its opinion as per the investigative findings that there were contradictions between the 2 pathologists. Remember, the state, you know, brought their own expert pathologists, Liberian pathologists. The defense brought a well-renowned pathologist from the U.S. To also give his expert opinion, and there were contradictions between the 2 pathologists. Remember, this is beyond reasonable doubt. So the Supreme Court, in its opinion, is going to establish whether or not there was reasonable doubt. And remember, these are all learned lawyers. These are experienced lawyers. It's no longer before jurors who are laymen and must rely on whatever that is brought to them. These are learned lawyers. These are experienced trial judges, and
this is where expert opinion comes into play.
And this is where it gets very interesting, Diamond. With the jury trial, you rely on people who are expected to be independent, to use their common sense. The jurors do not necessarily have to be legal practitioners to come down with their own position on those cases. So that was the case with the lower court. And there was a time when as we stated earlier, there were issues about jury tampering and stuff like that, despite the jurors being kept in an isolated place, isolated from the rest of the communities, from the family members and all of that, just to ensure that their decisions are not influenced. There were still issues raised, allegations about jury tampering. So where it gets interesting is that this is now before the legal practitioners, the people who will go beyond just the black and white to be able to determine who's wrong or who's right. And you go back to the initial point you just raised. That was a point of contention in the previous ruling. Well, the pathologist from the pathologist who was brought in by the family said that they saw the pathologist said after he did his autopsy, he saw there was a male DNA found. Now the pathologist from the state pathologist said there was no male DNA found. So that was the first place where it became a little bit contradicting, getting two pathologists, two individuals from the same line of profession providing conflicting accounts on a single case after conducting a autopsy.
There was also security expert contradictions as well as we followed the case. The defendants also brought in a former deputy director of the National Security Agency who also spoke to the vulnerability of the fence of the Chief Justice, that yes, there could have been the possibility of an intruder entering the fence because the back portion of the fence is not protected as the front portion of the fence. The state argued that the doors were not open until those who intervened broke in and opened the door, and opened the door by opening the window as well. Mind you, prior to this whole trial beginning, the state filed for a motion for change of venue. Remember that, Nelson?
Yeah, I remember.
The state found that they wanted a change of venue in July of 2023, based on the fact that this case was in the public spotlight, that jurors might have heard about the case, that jurors might have had their own sentiments about the case, and the jury selection process went a couple of days. We were right here on this very ground, where the jurors were asked whether they have any relations to any of the lawyers involved in the case, any of the judges, whether or not they heard about the case. And we had a lot of those who were not selected as jurors, but then 15 jurors were selected and they were isolated. The legal people used the word sequestrated for 5 months. This trial lasted for 5 months. The initial trial lasted 5 months, Nelson. Subsequently, the 4 defendants were found guilty. They walked right through this door. Councilor Musu's cat was shouting that she was innocent. It was a travesty of justice, and the rest. But fast forward to today, again, the Chief Justice is reading that there were various pathologist reports that there was a male DNA being identified on the left fingernail of Charlo Musu. So she's reading that there were reports of a male DNA being identified in the left fingernail of Charlo Musu. Whether or not she clawed at that person in a defensive posture, or however a male DNA got under the fingers of the late Charlo Musu, that is the reason, again, we're talking about, if this case, whatever the ruling is, there should be a revisitation of how we collect forensic evidence in our country, how we protect the integrity of crime scenes in our country, how we conduct scientific testing in our investigations, and the rest, because we cannot only always rely on eyewitnesses' accounts and confessions of individuals who are indicted or who have their day in court. If you have expert forensic investigators, if you have irrefutable scientific evidence, whether DNA or whatever scientific method that is used, is difficult to counter against.
and this is where maybe moving forward, the government will have to see reason to invest more in developing or building the capacity of our legal practitioners, or building the capacity of those in the investigative sector, those into forensic investigation and all of that, to ensure that they have what it takes. They have the sophistication to be able to carry on those kinds of investigation in a very timely and accurate manner. Because yes, we had the Gloria Musu card and others where there was a state pathologist brought into the picture. He conducted his autopsy, he came up with his report, but yet the family did not believe or did not trust what the pathologist who was provided, the pathologist provided by the state. That report was not trusted by the family, and so they had to bring in an independent pathologist who conducted his own autopsy and provided a report that was a little bit contrary to what the pathologist provided by the state said. Now, the other thing here is with the male DNA. Now, the 4 persons convicted in this case, as per the initial ruling, are all females. They are all females. Now, you go back to the autopsy report from the pathologist provided by the state. His autopsy report revealed that there was no male DNA. Now, the autopsy report from the pathologist provided by the family says there was a male DNA. Now, if you go back to the 4 persons, as I said, who are being convicted in this case, who are filed for this appeal, and now we're waiting for what the outcome is from the Supreme Court, they are all females. So if for any reason the Supreme Court gets to establish that there was a male DNA, then it's going to raise further questions as to where was the male. Why is it that there is a male DNA, but the individuals convicted are all females? Where was the male? Who could that male possibly be? This might just provide the basis, or provide more reasons why the Supreme Court will have to investigate further. But as it stands, the Supreme Court has done due diligence. All of these reports, the ruling that is being read now is going to come up with a final decision in this case, seal this entire thing with respect to whether or not Councillor Gloria Musu's card will be set free, or she will be further, or the Supreme Court will uphold the ruling from the lower court. And so this is where it stands now, and we will provide you the updates here every single step along the way. Now, right after this ruling, we look forward to seeing what comes from the Supreme Court with respect to the gracious right situation. Diamond, you know that Liberia is one country that has struggled with corruption over the years, to a point where when someone gets appointed, when someone is given the opportunity to serve in public office, the next thing out there, the perception from the public is that that person is automatically a criminal. And to a larger extent, Liberians will blame the underdevelopment of the country, the suffering that the ordinary Liberians go through on a daily basis. They will blame it on the high level of corruption that is being perpetrated by those in authority. So this is where the case today with the gracious right comes in. The president set up an asset recovery and retrieval team. This team has been going out, doing their job, and as part of their function, or in the process of performing their duties, the gracious right was caught in the web. A gracious right is linked to the former chief of protocol of the chief of protocol of the former president of the Republic of Liberia. And so with this case, yes, like the case with Councillor Gloria Musu's card, yes, we know there's a political attachment to this whole thing, but you come to the legal aspect. This gracious right situation, the ruling from the Supreme Court today, like in the case of Councillor Gloria Musu's card, will determine as to whether public officials moving forward will be more careful as to how they go about, especially while still in office, how they perform their functions, how they manage state resources, or as to whether those public officials will still go. There's no reason to come down with how do you call it, with some sort of a guilty verdict or what have you. But this will be a defining moment in terms of determining how public officials conduct themselves. There is a process in our country where when one gets appointed or selected to serve, you have to declare your asset. That way people get to know how much you're coming into government with. After 3 years you have to redeclare. Upon exiting government you have to again declare. When you're promoted you have to declare, and all of those different steps. We have seen over the time that officials of government, majority of them, have not lived up to the very code of conduct. So coming back to the gracious rights situation, the ruling today from the Supreme Court might just determine as to whether public officials will be will be more concerned about declaring their assets and conducting themselves well as they serve in public offices, or whether we are going to see business as usual.
Well, Nelson, I'll begin with whether we'll see business as usual. We've seen the ombudsman being established with individuals appointed to the offices. They were subsequently, commissioned by the President of the Republic of Liberia. Mind you, that is unprecedented. Yeah. And the ombudsman is to deal with code of conduct issues as such, or allegations of abuse of office by public officials. Yeah. So that is in itself a step in the right direction when it comes to accountability, transparency, and the respect to the rule of law by public officials, whether declaration of their assets in a stipulated time frame or amassing illegal wealth using government positions and the rest. We also have the LACC. Yeah. The LACC has the statutory responsibility to investigate allegations of corruption by public officials as well. So we have these institutions already in our country. What we've seen prevalent in the Liberian society is this big man untouchable syndrome. Yeah. If you look at the Executive Order 126, it seeks to immediately put an effect or a stop to the illegal acquisition of state assets, yeah, and those who are illegally holding state assets and don't want to turn them over. The accusation against Gracious Right is that those vehicles were donated to the government of Liberia, so thereby they are state assets. Mind you, Gracious Right is not arguing whether the vehicles are state assets or not. They're arguing that the establishment of the Asset Recovery and Property Retrieval Taskforce in itself was unconstitutional. The government is arguing that yes, the president has got the constitutional mandate to have established such. Mind you, executive orders go for 1 year, and they can only be renewed thrice. They can only be renewed 3 times. Whether President Bwaka, in his fight against corruption and illegally amassing wealth at the detriment of the people, felt that an executive order would have solved the problem while they try to find a more robust and permanent situation, the Supreme Court is going to render a verdict, an opinion. The full bench, again, these are well-learned lawyers. They're using constitutional reliance, they're using precedent cases and the rest. And mind you, this ruling in itself is also going to be a precedent. This ruling has got far-reaching effects politically and legally as well. There will always be political connotation once we have multi-party democracy in our country. We all cannot belong to one particular political grouping. So the ruling today is definitely going to send ripple effects. It's going to empower, if it is in favor of the Asset Recovery Taskforce, or it is going to hurt immediately, meaning the president will have to re-strategize, whether by going to the legislature to promulgate an act or a law to create an asset recovery task force, or by amending the LACC Act and adding an asset recovery and property retrieval task force as well. But before I get to your next question, Nelson, updates from the ruling, the opinion in the appeal filed by the former Chief Justice of the Republic of Liberia and 3 co-defendants. The Chief Justice is still reading. She has also stated that the state failed to provide individual roles that were played during the stabbing of the deceased 9 times. So she's reading that the state failed to provide the individual roles that were played by the 4 defendants in the stabbing of Gloria Musu 9 times. Remember, the prosecution argued that one person could have committed a murder, but others could have become accessories to murder after they observed what happened. Their actions after Gloria was stabbed could have implicated them in conspiracy, but mind you, the state failed during the trial proceedings in the lower court, according to what the Chief Justice is reading, to have established the individual roles of Councillor Gloria Musu, of Gertrude Newton, of Old Lady Ude Wisner, and Alice Johnson. So the state failed to have provided what individual roles they played, whether one person carried out the stabbing, 2 persons carried out the stabbing, 3 persons conspired after she was dead, all 4 of them conspired to have stabbed her, and what was the motive to have carried out the stabbing of Gloria 9 times?
At Diamond, again, this is where it gets interesting, because and it depends on the particular portion of the ruling that the Chief Justice is reading now, because the prosecution provided her own side of this whole thing, provided pieces of evidence, provided the information necessary to prove beyond all reasonable doubt that the four individuals convicted carried on the act. The defense counsel, on the other hand, provided information, provided all necessary documents to prove that their clients, or the 4 individuals convicted, the 4 convicts, did not commit the act. So again, what the Chief Justice would do is that they will go through all of those pieces of information provided by both the defense and the prosecution, and then following that, they will come up with a root. They will hand down a ruling. But what I'm seeing here, Diamond, is that most of the updates we're getting now
it's not in favor of the prosecution.
It's not in favor of the prosecution. So far.
It doesn't point to what the final opinion of the Supreme Court will be.
Definitely.
But as we said, these are well-learned lawyers. These are legal luminaries, and again, they were referencing what pieces of evidence presented to them from the trial in the lower court. Mind you, you cannot change. You cannot bring new witnesses to the Supreme Court. It's not a place to go and hear arguments on new trial and all of that. It's what is handed from the lower court that you take to the Supreme Court of Liberia, and you argue why you should be acquitted, whether it should be the legal people have a mistrial, or the Supreme Court will say, okay, it's a mistrial and hereby we've reversed the ruling, or the Supreme Court will say, look, based on all of the evidence and all of the arguments thus far, yes, the ruling from the lower court should be upheld. But so far, these are 2 major points. And before I read 2 of the points so far from the Chief Justice, the strategy of the defense team in the lower court is to establish doubt. That is just the strategy of any defense team in a criminal case where your clients are accused of committing a capital offense, is to establish doubt. Doubt number 1. How can 4 persons conspire to kill 1 person? What is the motive? How did they do it?
What's the possibility?
What's the possibility?
Is it that all 4 persons
decided to kill Chalo?
Held
what was the reason?
Yeah.
Did they have anything of animosity against her? 1. 2. What benefits? Where is the murder weapon? What was used? Investigative techniques. We're trying to tell you that this place could have been entered into. Yes, our witnesses are saying that yes, this place can be broken into, as against you saying it cannot be broken into. These are weak spots. So you're trying to create reasonable doubt. As any defense attorney in a criminal case, you have to establish reasonable doubt. And for the Chief Justice so far, from what we're getting, to have pointed contradictions in the pathologist's report, to have pointed that yes, there was the investigation showed that there was a presence of male DNA on one of the fingernails of Gloria Musu. The state failed to provide the weapon used. The pathologist report that there was a male presence in the DNA presence of a male DNA present under the fingernail of the deceased. That the state failed to provide a role of each defendant. The High Court has reversed the ruling. That is the
Wow.
breaking news. The
Wow.
High Court has reversed the ruling of the lower court, meaning the former Chief Justice of the Republic of Liberia, Councilor Gloria Musu Start, and 3 other co-defendants have been issued a ruling, an appeal from the High Court that their verdicts have been overturned. They have been ordered to be released immediately, according to what we're getting from the Supreme Court of Liberia on these counts. 1, the state failed to provide the weapons used. 2, the pathologist report that there was the presence of a male DNA under the fingernails of the deceased, that the state failed to provide the role each defendant played, and the High Court has reversed the ruling of the lower court. Former Chief Justice Councilor Gloria Musu Start and 3 other co-defendants are hereby ordered released immediately by the Supreme Court of Liberia. You can hear the cheering. You can hear the cheering. You can see them coming downstairs. They have overturned the ruling. The former Chief Justice has been ordered immediately released. Nelson, there you have it.
So what we are remember, Diamond, when the initial ruling was passed, Diamond, there was a tense atmosphere here. A lot of people were very sad with respect to what the ruling was at the time. There were people crying all around the grounds of the
Supreme Court, that there is crying, there is wailing, there is cheering. The Supreme Court, the 4th bench of the Supreme Court of Liberia, has appointed the former Chief Justice of the Republic of Liberia and 2 other co-defendants. That is the breaking news.
Yes. Hello.
Thank you, sir.
Okay, you. Tell us, what's your impression about everything here today?
Should I say I'm speechless? All I can say is Gloria Scott for now. But it was in a my love, and
So what's your relation to the family?
Like you don't want you talking to.
The first son of
The very first human being that comes inside, let me hear. You from in the courtroom, tell us what happened here. Well, start right now. I'm going to put my mouth on water.
Okay, thank you very much. So
The Supreme Court has to send down a mandate to the lower court to have them reviewed. So are you released?
You talking about glass cow? What the hell? Do you know? The woman said the woman go.
So there you have it, folks. We want to show you all around the grounds of the Temple of Justice. There is jubilation as compared to some 7 months ago when she was convicted and subsequently sentenced to lifetime imprisonment along with 3 other co-defendants. Her first son is the one jubilating and dancing. It is a complete contrast from what occurred 7 months ago here on the grounds of the Temple of Justice. The state, according to the Chief Justice of the Republic of Liberia, failed to have provided the murder weapon. The state failed to have also provided the individual roles played by the 4 co-defendants. There was the presence of a male DNA under the finger. There was conflicting reports from both pathologists. Nelson, reasonable doubt.
exactly, Diamond. Reasonable doubt. I did see a very emotional scene here where one of those who was visibly seen here when the initial ruling was handed down. She was crying. She was in tears. I did see her coming out. We're gonna see as to whether we can talk to her. I saw her as well.
All across the Temple of Justice, Jurassic is going to turn the camera over this place from 1997 to 2003 as the Chief Justice of the Republic of Liberia. Whether or not the mandate is going to be handed now and taken to criminal court A, remember the prosecution is now present. The Solicitor General, the Ministry of Justice, they're not present, but the prosecution must be present for the mandate to be delivered to the lower court that the Supreme Court has ordered a reversal of their ruling. After that, you proceed to the Monrovia Central Prison and have them released. But the information has already reached that they have been acquitted of all charges. Murder overturned, criminal conspiracy overturned, making false statement to law enforcement officials overturned as well. What does this say to our criminal justice system in this country, Nelson? That the prosecution that has got all of the resources, all of the time, all of the money, we were told that the prosecution requested $150,000 United States dollars to have prosecuted this case, to have been slapped this way with an overturn in the verdict. I know it's a win for the Musu stat, but what does this say to prosecuting in Liberia and innocent Liberians who might be languishing behind bars for similar negligence?
No, Diamond, I think this speaks to the fact that our justice system needs to be overhauled. A lot needs to be invested into how the prosecution can further build the capacity of those in the justice system to carry on accurate investigation with respect to these different cases. Diamond, this is just one of many cases. As we speak to you, there are so many people behind bars. Some are pre-trial detainees behind bars. Some have not had the time in court like what Councillor Gloria Musu's had. Now, this is happening, and like you see, a lot of people around here. This is a high-profile individual.
Monrovia Central Prison, want to see he and his family members, they are exchanging hugs. As you can see, this is a contrast in what we saw 7 months ago. 7 months ago, it was wailing, it was crying, it was tears of depression, but now it's all about freedom. Their life sentences have been reversed, Nelson.
So if we were to just turn the camera this way, Diamond, you will notice that the atmosphere here is calm today. You know, as compared to that day when the initial ruling came up, there was tension.
Look at what happened, Nelson. This place was cleared a couple of minutes ago, but once the ruling was handed down from the full bench of the Supreme Court of Liberia, everybody have gathered here. So people were around just waiting because of the stringent restrictions employed by the security officials. Whether she will be released today, that is what we yet to see. Whether the mandate has been handed down, because it must come from the Supreme Court of Liberia down to Criminal Code A and subsequently taken to the Monrovia Central Prison. Who they want to release her and make all of the somewhat tension, or they want to do it Nicodemously at night and have her taken to her house? That is the question. But the acquitted, her family members are saying they are moving to the Monrovia Central Prison to have her released, and these are the counts the state failed to have provided. The state did not, according to the ruling from the full bench of the Supreme Court of Liberia, the state did not prove beyond all reasonable doubt that the four individuals committed the capital offense of murder, criminal conspiracy, and making false statements to law enforcement officials. The Chief Justice, reading this opinion from the full bench of the Supreme Court, said the state failed to have provided the weapon or weapons used. The state also failed to have pointed out the roles played by the four individuals in the stabbing of Gloria Musu 9 times. The state also, the pathologist report stated that there was the presence of male DNA under the fingernails of the deceased, thereby establishing reasonable doubt. So 4 counts. The state admitted that prior to the burglary, they have burglarized the defendant's home twice. So Nelson, the fact that the defendant's home was burglarized twice prior to this incident also refuted the state's claim that this place was impenetrable as well.
Exactly. We want to speak to this. Hello, sir. Welcome to Spoon TV.
Thank you.
You want to come this way? Let's face the light. Okay. So welcome to Spoon TV.
Thank you very much.
You are the spokesperson of the family. I saw you here on the very day the initial ruling was handed down in a very emotional mood. You were in tears. I see you jubilating today. Give us your impression about everything that has happened. Do you now trust the legal system of Liberia?
On the former the other side in the sky, but today it's just happening that we lost our sector. Firstly incriminated her, they persecuted a family member in Justice Card as well.
So today just the beginning of the achievability of the justice, the transparent justice that we aim for.
So what's the next course of action? What is the family planning to do next? Following
let me tell you.
today?
Look, she's been acquitted. She's been acquitted. The reality is she was being prosecuted by the past government, and this government have inflicted a lot of damage on her. You know it. So the family is going to make an informed decision. But the reality is that the past government firstly incriminated her. We indicated it. They went after exterminating her daughter. They killed her daughter. They killed her daughter. They wouldn't went out of Gloria because of her status.
What's that grave on the legal system?
No. I was always on radio. I did indicate that the former Solicitor General was a criminal. I did indicate that the former county attorney was a criminal, evidenced by the fact that they were inducing jurors all around the place. I indicated that Bobby Livingston, Adolphus Kanwa, and the rest of the guys are all criminals.
Are you moving to South Beach right now to go and get a release?
The Supreme Court, we is the higher court of the land, said arrest and privileges are now immediately restored.
Okay, so yeah, let's see if we can talk to the legal team. Welcome to Spoon TV.
The Lord is great. We were here at the beginning. We were here to see justice done. We thank God. We thank God. Thank God. All the lawyers, we thank all of you. We thank the Supreme Court. Thank the Supreme Court.
The initial ruling,
I got no initial ruling. All I'm saying to you, I thank God that I was able to be here to hear justice done. We thank God. That is what I've got to say. I've got nothing else to say.
Did you expect the ruling here today?
We are very happy with the ruling. We are very, very happy with the ruling.
Do you trust the legal system now?
We are very, very pleased with this decision of the Supreme Court, and we thank God for the lawyers. We thank God for the detailed presentation that was made to let the public know the details thereof and the basis for the decision.
So what is the legal team contemplating on now following this ruling? What's the next course of action? Your client was behind bars for several months. What is the next course of action?
I am not a lawyer. I have spoken. I have nothing else to say. Speak to the legal team. Okay? Thank you very much.
Okay, thank you very much for talking to Spoon TV. Of course, let's see if we can talk to. Okay. So we are waiting on the former impeached. So we are now waiting on the former impeached Justice Kabina Jane, and of course once he arrives, then of course we will get to talk to the legal team. So Spoon TV, thanks for joining us. Thanks for joining us. Let's see if we can talk to some of the family members. How are you, Mama? What? So you are happy? How do you feel about the ruling today?
I'm happy because my sister is not a murderer. Yes, even though we have lost for telling a child from 2 years to finish college, the very day they gave clearance, the very night they killed her. But God be our judge. Our sister will be free today.
So you waited for the moment that you wanted that you were going to come?
Yeah, I waited because I know she is not that. She's not that kind of person.
Thank you for talking to Spoon TV. I see Senator Blebo Brown here. Welcome to the media, sir.
Not just my former colleague, but she was Senator of Maryland County. And I think the decision, the judgment, the ruling of the Supreme Court was profoundly sound. I mean, if we had any other ruling other than this, would have been surprised.
Were you surprised with the initial ruling?
The initial ruling left a lot of doubts. How can you say that male chromosomes were found in the fingernails of the deceased, and yet all those that were charged were females? So a lot of doubts, and that's why we appreciate the decision of the Supreme Court. As the people of Maryland County, as a family, we appreciate this decision. Councillor Scott should be set free, and she will be set free. However, we're still not happy that the killer, the actual killer, is still alive. And so the county, the family will be pushing the Ministry of Justice to set in motion a framework that will identify, arrest, persecute, and incarcerate the actual killers of Charlotte Musu.
Senator Brown, we have seen two separate trials here, the jury trials and that of the bench trial from the Supreme Court. Will you recommend jury trials in our judicial system, given what we've seen?
Definitely, the Supreme Court is the last place. So all cases start with the lower case. Unless you appeal, then it comes to Supreme Court. So that's where we should go. We have to strengthen the the courts. Yes.
Thank you. Thank you, Senator Gloria Brown of Maryland County, Spoon TV. Of course, we are here, folks. Let's see if we can now. We are now making our way